Hello, and welcome to the Washington Courts Report podcast. I'm your host, Patric Haerle, and for today's episode, I'm going to be covering the 2026 State of the Judiciary Report. This report is presented each year by the Chief Justice of the Washington Supreme Court to inform state and local lawmakers and the people of Washington about the challenges, problem-solving efforts, leadership changes, and other news of the courts and judicial branch in the past year. The report itself is just a snapshot of some of the tremendous work being done every day in our courts and judicial branch agencies. The hope is, providing a snapshot of those efforts will give lawmakers and the public a sense of all the hard work that is constantly happening to advance the judicial branch. So consider this episode a snapshot of the snapshot. I'll be briefly covering a few of the highlights of the report, but if you want to learn more, I really encourage you to read the full report, which I'll link in the description and on the Washington Courts Report webpage. So without further ado, let's dive right in. First things first in the report is a column by Chief Justice Deborah Stevens, where she touches on some of the many topics covered from the report. I won't try to paraphrase the Chief Justice here, but the column gives some great insight from the Chief into many of the topics I'll be covering today. And if you want to hear more from Chief Justice Deborah Stevens, I highly recommend the recently released Inside Olympia episode on TVW, where she was interviewed as a guest, which I'll also link in the YouTube description and on the podcast page. So the report itself is broken up into 6 sections, the first of which tackles some of the major equity and access efforts that have been underway over the past year. The first article covers all the great work of the Supreme Court's Minority Justice Commission in 2025. The commission is charged with the mission of ensuring that all courts in the state of Washington remain free of bias so that justice might be adjudicated in a neutral and fair manner. The Commission recently released their annual report, so if you'd like to read a more in-depth description about its important work, you can find it on the Minority and Justice Commission webpage, which will be linked as well. You can also listen to the podcast episode released just a few months ago, where I interviewed Commission co-chair Judge Veronica Galvan and Commission staff Frank Thomas about some of the great work of the MJC. In 2025, the Commission held their annual Supreme Court Symposium, serving as a call to recognize the generational harm caused by the abusive treatment of Native communities and their people. A full-day event, the symposium featured a screening of the award-winning film Sugar Cane, a lecture on tribal self-determination, and presentations on intergenerational trauma, violence against Indigenous people, and restoring Indian child welfare. Symposium materials and a recording of the full symposium can be viewed at the MJC webpage. Also in 2025, the Minority and Justice Commission published its comprehensive statewide youth diversion report that evaluates mechanisms, impacts, accessibility, and disparities in the administration of youth criminal diversion in Washington state. Diversion refers to any informal resolution that interrupts the ordinary formal prosecution of a criminal matter. A common example is a diversion agreement, whereby an individual agrees to meet certain conditions, usually over a specified period of time, after which the prosecutor agrees not to prosecute the case, or if the case has been filed, to dismiss it. The focus of diversion is rehabilitation rather than punishment. The report identifies key trends in diversion programs nationwide, features research on the positive outcomes of diversion on youth, identifies principles that youth justice systems should adopt and operate under, and provides recommendations based on research, reform, and investment into diversion programs. Another highlight of the Equity and Access section was the work of the Administrative Office of the Court's Equity and Access Program over the past year. The program was established to help courts serve the growing needs of self-represented persons in Washington and address the needs of court users from communities that have been historically marginalized and oppressed in the United States with the least access to justice. More than 30 million Americans deal with legal issues without a lawyer every year, and for low-income individuals, 92% of those issues receive little or no legal help. Here in Washington, the Equity Access Program is working to close that gap. The program recently hosted a statewide self-represented litigants summit and is preparing to release a new statewide plan aimed at making courts more accessible for people who don't have attorneys. Stakeholders at the summit discussed the biggest barriers facing self-represented litigants and what solutions are already in motion. A draft version of the statewide plan will be posted in the coming weeks for public input, with a final version expected later this year. The plan lays out 9 major recommendations, from strengthening courthouse resources to expanding alternative ways to resolve cases. And the planning is already underway for a virtual follow-up summit in 2026. Meanwhile, the Equity and Access Program has launched a new online resource called Self-Help Washington. It's designed to help people navigate the court system on their own, with guidance on topics like ADA accommodations, guardianship, housing issues, court prep tips, and more. Users can also learn how to request interpreters or disability accommodations and watch helpful videos on basic legal topics and how to appear in court using Zoom, for example. More features are coming soon to Self-Help Washington, including multilingual translations, a legal glossary, and a visual guide to court processes. The next topic for the State of the Judiciary Report is the administration of justice. For this, there were some really interesting highlights, such as the Washington Supreme Court adopting a new passing score for the bar exam and setting the score for the upcoming next-gen exam. So in late 2025, the Washington Supreme Court issued an order setting passing scores for the current uniform bar exam, currently used in Washington State, and the next-gen uniform bar exam, which will take effect later in 2026. The passing score for the current exam moved from 266 to 260 and is retroactive to 2020. Anyone who took the legacy exam in Washington between July 2020 and July 2025 and who scored between 260 and 265 is now eligible to apply for admission as a lawyer in the state per the order. The Next Gen Uniform Bar Exam, or UBE, was developed by the National Conference of Bar Examiners. Adoption of the new UBE and setting scores for both the old and new exams were part of recommendations made to the court in 2024 by the Bar Licensure Task Force. The task force worked for 3 years gathering data, research, and testimony and arrived at 2 important findings. The traditional bar exam disproportionately and unnecessarily blocks marginalized groups from entering the practice of law, and the traditional bar exam is at best minimally effective for ensuring competent lawyers. The task force findings led to the state Supreme Court approving alternative pathways to lawyer licensure, as well as the new exam and new passing scores. Also, in the Administration of Justice section, was the Supreme Court approving pilot program for entities providing legal services. In late 2025, the Washington State Bar Association launched a pilot program to authorize entities, such as nonprofit organizations and businesses, to provide some legal service in the state under carefully monitored conditions. Current state regulations allow only licensed individuals to provide legal services, and only licensed individuals may own law firms and practice law. The pilot program was authorized by the Washington Supreme Court to allow the WSBA and the Practice of Law Board to research whether allowing the new modes of delivering legal services and closely regulating entities that do so will increase access to justice by enhancing access to affordable and reliable legal and law-related services consistent with the protection of the public, and whether entity regulation will create risks of consumer harm, regulatory challenges, or other risks that would serve as barriers to implementing reform. The pilot program began taking applications in October 2025. The project creates a pathway for legal service business models that make use of innovative technologies or non-lawyer advocates. Washington joined several other states, such as Utah, in allowing entities to test innovative service models. The pilot project is authorized for 10 years. The Supreme Court will evaluate the accumulated data, findings, and recommendations to decide whether to make permanent regulatory changes. Next up in State of the Judiciary was the section on different programs around the judicial branch. We'll start with an update of the Washington's Hope Card program, which launched just over a year ago on January 1st, 2025. The program gives survivors a wallet-sized, easy-to-carry version of their civil protection order, something they can quickly show to law enforcement, employers, school, or landlords if an order is being violated. Again, this was another great topic we covered on the podcast, so you can go back and listen to that episode if you're interested in learning more. In its first year, the program has issued more than 4,000 Hope Cards across more than 1,500 cases. The goal is simple: make it easier and less stressful for survivors to carry proof of their protection orders, which are usually lengthy documents. A year-end report is coming soon and will be available on AOC's Hope Card website, along with request forms and more program details. A media toolkit is also in development to help raise awareness. Hope cards are free and available to anyone with a valid full civil protection order, including domestic violence, sexual assault, stalking, anti-harassment, vulnerable adult, and extreme risk protection orders. Cards remain valid as long as the underlying order is active and turnaround times have averaged under 3 days. Up next for programs, an update on the statewide Blake relief efforts. In 2025, the Administrative Office of the Courts continued its work helping people impacted by decades of simple drug possession convictions that were ruled unconstitutional in the State v. Blake decision. A major milestone this year was the launch of the Blake Administrative Vacate Unit. Under direction from the Washington Supreme Court, this new unit helps courts vacate 50 years worth of affected convictions. Courts can opt in, and the vacate unit prepares the motions and orders for them. No legal advice, just administrative support to help ease the workload on already stretched court staff. On the financial side, the Blake Refund Bureau has now issued more than $6.6 million in refunds since launching in 2023, with $31 million still available. This innovative work hasn't gone unnoticed. The Refund Bureau received the Washington State Bar Association's 2025 Apex Legal Innovation Award for its first-in-the-nation approach to clearing records and returning fines and fees. If you want to learn more, you can listen to our podcast that we held with the Blake Refund Bureau staff, which featured some great insight and stories about the work being done to refund court fines and fees. Next up was the people section of the State of the Judiciary. And there's really nothing better to cover here than the historic turnover that has been taking place on the Washington Supreme Court and will take place over the next year. This includes the 2026 retirement of two of the longest-serving justices in state history. From January 2025 to January 2027, no fewer than 5 new justices will sit on the 9-member state Supreme Court, a transition not seen in decades. The 5 departing justices will have served nearly 112 years on the court. The longest-serving justice in state history, Associate Chief Justice Charles W. Johnson, will retire when his term is over at the end of 2026. Justice Johnson, who will reach the retirement age of 75, as constitutionally mandated, was elected to the court in 1990 and began serving in January 1991, giving him 36 years on the court. The second longest-serving justice in state history, former Chief Justice Barbara Madsen, announced her retirement effective April 3, 2026. Justice Madsen was elected to the court in 1992 and began serving in January 1993, giving her more than 33 years on the court. Justice Madsen was the first woman to be popularly elected to the court and was only the 3rd woman to serve. She was also just the 2nd woman to serve as Chief Justice and the first woman to be elected to that role twice. Justice Raquel Montoya Lewis, who has served on the court since January 2020, announced that she will not seek re-election this year. Justice Montoya Lewis is the first Native American justice in Washington history and only the 2nd Indigenous person to serve on any state Supreme Court. The retirement of these 3 justices follow that of 2 other justices in 2025. The late Justice Susan Owens served on the court from January 2001 through 2024, retiring at the end of her 24th year. She began her judicial career as the first woman on the Clallam County District Court in 1981 and was a champion of rural and tribal courts and a leader in judicial education. Justice Mary Yu retired at the end of 2025 after 11 years on the Supreme Court and 25 years on the bench, having served on the King County Superior Court for 14 years. The daughter of immigrants, she was the first woman of Asian and Hispanic descent to serve on the court, as well as the first member of the LGBTQ+ community to openly serve. She was a longtime co-chair of the State Minority and Justice Commission and was deeply dedicated to mentorship and judicial excellence. Following the retirements of Justice Owens and Justice Yu, 2 new members have joined the High Court over the past year. Justice Sal Mangia, elected to the open position left by Owens' retirement, took office in January 2025 for a 6-year term. Justice Colleen Melody was appointed by Governor Ferguson to the position opened by Yu's retirement and took office on January 1st of this year. In addition, Governor Ferguson is anticipated to appoint a new justice in the coming weeks to the position created by Justice Madsen's retirement. Next up, we have a section on awards. One of the highlights of this was the Judge of the Year Award that went to King County Superior Court Judge Leroy McCullough. The Outstanding Judge Award is presented for outstanding service to the bench and for special contributions to the legal profession at any level of the court. Joining the King County Superior Court in 1989, McCullough has served as the chief presiding judge of the Malang Regional Justice Center and the King County Juvenile Drug Court. The Washington State Bar Association highlighted McCullough's commitment to civic education. Another highlight of the award section, the Chief Justice Mary E. Fairhurst Award of Merit being awarded to Justice Susan Owens. The Chief Justice Mary E. Fairhurst Award of Merit is the bar's highest honor presented to an individual for a recent singular achievement. The WSBA recognized Owens for her barrier-breaking leadership, whether working to improve services for marginalized communities or championing the cause of those voices, who are too often drowned out. Owens was one of the first women attorneys in Clallam County when she moved to Port Angeles in 1976 to work as a legal aid attorney. In 1981, she became the first woman judge on Clallam County District Court. As a judge, she became committed to improving judicial education on domestic violence cases, helping to author a bench book, and becoming a national trainer on the subject. Also for awards, I gotta mention the Court Manager of the Year Award, which our most recent episode just covered, went to Marlon Markley of Whitman County District Court. I highly recommend giving that episode a listen if you have a chance. It was a great interview with Marlon and some great insight into court administration. And wrapping up our coverage of State of the Judiciary was a section on public outreach. And we'll start with taking a look at the work of the Public Engagement and Education Committee, or PEEC. Formed in 1999 by the Board for Judicial Administration, this volunteer group is dedicated to improving the public's understanding of Washington's judicial branch. Its members include judges, lawyers, educators, court staff, and community representatives. The mission is twofold: help the public understand what courts do and build trust through accountability and collaboration. To do that, the PEEC runs a wide range of civic education programs. Long-standing offerings include Judges in the Classroom, where judges visit K-12 classrooms to teach interactive lessons about law and fairness, and the statewide YMCA mock trial program, which gives students a hands-on courtroom experience before real judges. This year, PEEC launched a new initiative, Lawyers in the Classroom. It's a partnership among the state courts, AOC, and the Washington State Bar Association, allowing teachers to request a lawyer to deliver age-appropriate lessons on the judicial branch. The program grew out of 2025 Law Day events focused on reaffirming oaths to the Constitution. This year, the PEC is also working with TVW on several video series. The first answers common questions about courts, like the difference between civil and criminal cases and how to find legal help. TVW is also producing videos about the functions of Washington court levels and key concepts like separation of powers and procedural fairness. And that wraps up our coverage of the 2026 State of the Judiciary Report. I hope you found this information insightful. And like I said before, I highly recommend giving the full report a read through when you have the chance. That's been our episode today. Thank you for listening.